Pitfall number 5, not planning for disability. All of what we've talked about up to this point has pretty much been directed at the happy subject of what happens when you die. Now we're going to talk about the even happier subject of what happens if you become disabled during your lifetime, which frankly, nobody ever wants to happen. And maybe most of us realize, okay, we are going to die. We do need something to direct where assets go, whatever they may be, however modest they may be when we die. But nobody wants to think about disability. And I have to tell you that as an elder law attorney, one of the things that we focus on is what happens if you become disabled? What happens if your spouse becomes disabled? What happens if your adult child becomes disabled? This is really the area that is so important to me as an elder law attorney because it is so overlooked by other attorneys. And it has probably the biggest impact. It has the biggest impact on the person that's disabled, for sure, because they're still alive. And so this is their life. And if they can't speak because of, a brain injury or advancing cognitive decline, that's a big problem. It's a problem, at least from the legal perspective, we can help alleviate by putting the right documents in place. And that is, having in place a document with legal authority giving somebody else the ability to speak on your behalf. These are what we call living documents. These are what we call durable powers of attorney. So people don't like to plan for disability. What I said previously is that estate planning, elder law is all about planning for the what if. So what if on somebody's drive home, they're in a car accident and they're severely injured and they can't speak for themselves either temporarily or permanently? We need to have durable powers of attorney in place. What are they? They are the document that you sign while you are capable and you say, hey, if I am disabled, I want my spouse to be able to make decisions for me. And if my spouse and I were both in that same accident, I want this adult child. And if then that person can't, then I want this person to. I'm putting a roadmap of decision-making authority so that somebody that I trust who is capable will be able to be my voice when I can't speak. That is the power of durable powers of attorney. So why they're overlooked, I think, is that people don't want to plan for disability, but life certainly does happen. And we've got to plan for that. And your attorney has to be talking to you about durable powers of attorney. Frankly, if they say all you need is a will, that is a huge red flag. You need durable powers of attorney. You need the whole estate plan, but critically important are the durable powers of attorney. The other living document also is your healthcare directive. It's called a living will. It's called an advance directive. That's the document that says if you are at end of life, what kind of treatment do you want? Do you want heroic measures? Or do you want to be allowed to pass as pain-free as possible without medical interventions? I mean, that's your choice, but put it in writing so that people do know and who's going to speak for you. Designate your healthcare agent through a durable power of attorney for healthcare. Who's going to be managing your legal and your financial matters? That's your financial durable power of attorney. I say durable because your document needs to be durable. It has to withstand the test of time. It has to go on and have authority even after you can no longer make decisions for yourself. That's why it's called durable. So I guess the next question would be, what happens if something thing causes you to lose your ability to make your own decisions, and you don't have your durable powers of attorney in place. So what happens there is that the court is going to need to step in. And the court will need to step in because you have nobody to speak for you. You might go, well, no, I'm married. My spouse can speak for me. They can't. Even in Washington, even in a community property state, there needs to be something that grants legal authority. Being married isn't enough. The court may appoint your spouse as a guardian, but there needs to be the guardianship, also called a conservatorship, for somebody to have legal authority to speak on your behalf. Being married doesn't provide that legal authority. Frankly, think about this. Have you ever tried to call on your spouse's credit card and they say, put your spouse on the phone? That's just a very simple, tangible example of that you don't have legal authority. So legal authority comes through a durable power of attorney or through a court-ordered guardianship conservatorship in the event somebody has lost capacity. I think it's probably pretty clear that the recommended approach is avoid the court, go with a durable power of attorney. That means you need to plan before you lose capacity. So failing to plan for incapacity, for disability, means that if it happens, the court is going to be involved. And if you are married and you're surviving, or your spouse who's non-disabled, even if they're appointed as your guardian, they have to run everything through the court. They will have to have an attorney to help them. The court will have to approve of any type of personal care plan, financial plan. Your spouse wants to sell the house, they need to get the court order approving it. Far more costly, cumbersome, complex, not a good result. So plan for disability, and then let's hope that disability never happens, which is the best outcome. So key takeaway is that estate planning is not just about death. I think more importantly, it's about life. And it's about getting that peace of mind that you have durable powers of attorney. So you planned for disability and incapacity, and then it doesn't happen. But at least have the peace of mind that tells you can walk away and say, I've got the right plan in place. I know I have the right plan. So now I don't have to worry about it anymore.